Any mention?
May I please, Your Lordship, I beg to mention items 6 and 8, Your Lordship.
Number
6 and 8.
Number 6 and 8.
Yes, Your Lordship. Nokma Council, Your Lordship.
This matter has been repeatedly adjourned.
The senior counsels on sanction leave, Your Lordship.
Mr. Siddiqui.
Yes, Your Lordship. Your Lordship, I pray for 4 weeks' time, Your Lordship.
Number 6 and
8.
May it please Your Lordship. Then item 7 also will have to go, Your Lordship.
yes.
Then item 7 also will have to go, Your Lordship.
Matthew Sangma.
Lordship,
Who's
yes.
the waiting for the petition?
filed my rejoinder, Lordship, on the as per the last order dated.
In
It's a
item
corrected
7.
matter. Yes, I have filed it.
Mention is made on behalf of Mr. A. Siddiqui, stated to be on leave for adjourn items 6 and 8.
7 or 6.
No, 6 and 8. He's doing his
Lordship, yes.
objection.
Dear pleasure, no.
Their pleasure.
Your Lordship,
Too wide.
kindly accommodate us for weeks' time, Your Lordship. As the senior conducting counsel is on, he left for his Hajj, Your Lordship. So he
Hajj
won't
surgery?
a pilgrimage, Your Lordship. So
Then I'll have it after 4 weeks.
After 4 weeks. Lordship, yes.
Just after 4 weeks. As item number 7, this matter being connected to items 6 and 8, it is together on the next date. Stop. Mr. P.T. Sangma submits that rejoinder
Lordship.
has since been filed. Yes. Yes, accordingly on so and so. Yes. Yes.
much obliged, Your Lordship.
Deeply obliged, my Lord.
Item number 1.
Number 1. Oh.
Lordship, I've received instruction on this matter, Lordship. Lordship, the option to file updated return is, as per my instruction, is available under section 139(80) of Income Tax Act, Lordship. May I read the section, Lordship?
One second. But see, his only grievance is that you direct him to file before the appellate authority.
Lordship.
So if you file for appellate authority, he says he lose a ladder of appeal.
Lordship,
So he wants to file the physical return
Lordship.
before the who's that?
Before the assessing officer.
Assessing officer. Yes.
Lordship, the option to avail this section 139(80) is available online as well, Lordship.
It's only
Available
online.
Online.
He wants to file physical returns.
Because we don't have that option. Now, what my friend is saying.
One second.
is-
What's the
Lordship.
139?
Section
139?
Section
A.
139(8)(a), Lordship. 139(8)(a).
Double A.
No, it's
8A, 8A, Lordship.
8A.
8A.
All this is foreign to us.
22, and it has been amended again.
Long section 8A. Where the return of subsection 1.
Lordship, 8A, if Lordship allows me to read it, Lordship.
Yes.
Any person, whether or not he has furnished a return under subsection 1 or subsection 4 or subsection 5 for an assessment year, herein referred to as relevant assessment year, may furnish an updated return of his income or the income of any other person in respect of which he is assessable under this Act for the previous year relevant to such assessment year in the prescribed form, verified in such manner and setting forth such particulars as may be prescribed at any time within 24 months from the end of the relevant assessment year. Lordship, this period of 24 months has been extended to 48 months by Finance Act 2025, Lordship. Now, Lordship, what I propose is, Lordship...
No, see, the thing is that your prayers for physical filing.
Lordship.
and as per my instruction,
Nowadays,
Lordship...
they don't have physical filing anymore.
No, Lordship, as per my instruction...
Stopped totally.
Stop, Lordship. Stop. This option is not available at all, Lordship.
Then
So what my friend is submitting on instructions is that in view of 139(8)(a), I can avail this option. Now, the only problem in my understanding of 8A, if your Lordships will just come back to 8A, it says any person, whether or not he has furnished a return under subsection 1, 4 or subsection 5 for an assessment year, herein referred to as the relevant assessment year, may furnish an updated return of his income or the income of any other person in respect of which he is assessable under this Act for the previous year relevant to the assessment year. Now, please see what the definition of previous year is, my lord, under section 3. it speaks of the financial year immediately preceding the assessment year. So I'm not sure if 8A will apply.
Lordship, I have taken instruction on this, and as per my instruction, this will apply, Lordship. What I propose, Lordship, is that let the SSC company avail this section 11380, or at least make an attempt to
If it's
avail.
online, it will be rejected automatically then.
Lordship, as per my instruction, it will be accepted, Lordship.
How? You can tinker with the system.
So what
This option is available.
I've just consulted. If your lordships give us a week's time or 2 weeks' time, we will try to avail this option under 8A. If it is not available to us, we'll come back before your
Yes,
lordships,
Lordship.
and lordships may pass necessary orders. If it is accepted, then the appeal may be closed.
Take down today Mr. S. Pandey, Learned Counsel for the respondents from Tax Department, has submitted that to the prayer of the writ petitioner. The remedy lies in section 139 and the bracket 8A capital, which he submits the petitioner can avail of. Stop. Therefore, to this submission, Mr. S.L. Learned Counsel of the petitioner prays that we allowed to attempt.
Well, we'll take instructions from the
yes,
client. If it is available,
may be
we'll
allowed to take instructions as to whether the same can be
availed.
availed of. Yes. He prays funds allowed how much time?
A week's time, Lord.
1 week.
2 weeks time, Lordship.
I'll leave it to your lordships.
Yeah, 2 weeks. Just accordingly and so on. So prayer allowed, yes.
Oblige, Lord.
But then nowadays, I don't think physical fight.
there is-
Because how do they monitor? They monitor everything is through, it's monitored through.
There is no provision for
digital
physical firing,
monitoring,
Lordship.
yes.
Even the tribunals are faceless now.
Yeah, the face is.
Lordship.
Also, by Lordship.
I'll oblige, Lord.
Yes.
Item number 2.
One thing that also. To upload everything for. And the fellow play with himself. Into the video. Into the system. Yes. Who's filing for the petitioner? Yes.
Rejoinder affidavit has to be filed by us, but due to some unforeseen circumstances, what happened yesterday, his mother-in-law passed away, and few weeks back, her mother passed away. The family is not in a rightful situation right now. Lordship will grant us more time for filing of this joint affidavit.
Okay. Your name? What is your name? MSS Datta on behalf of Mr. A. Bansal submits that due to bereavement of the arguing counsel, the rejoinder could not be filed. She prays. How much time?
Lordship, a month's time is granted. That will be very helpful right now.
She prays for allowed 4 weeks time. Yes, to comply with the same list after 4 weeks and so on. So, yes,
Item number
interim order of any shall continue. Yes.
Item number 3.
1 second. We'll note down. Is note. Corresponds to 6. Nephew also still.
Supplementary list. Pronouncement of judgment. Item number 1, 2, and 3.
Those settled law, the writ court should refrain or restrain itself from interfering in tender matters, and the principle of equity should not be brought into play. However, taking consideration the entire facts, circumstances of the case at hand, judicial review or decision-making process warranted to interfere with the arbitrary legal manner or award of contract. According for the reasons aforementioned, the entire tender process pursuant to NIQ dated 10/9/24 is hereby set aside. Consequential work orders issued respondent number 4 and 5 therefore shall accordingly also stand cancelled. However, keeping in mind that the matter concerns the providing of free roofing sheets to below poverty line families, which is vital to their shelter and well-being and a greater public interest, the state respondents directed to immediately float a fresh NIQ citing clear and unambiguous requirements in the terms and conditions thereof, and further endeavour to complete the entire process, preferably in a period of 3 months from the date of this order.
Apply, Your Lordship.
Any mention?
May it please His Lordship. I beg to mention item number 25, Lordship. Twenty-five.
Who's for the petitioner?
I'm for the petitioner, yes.
Objection?
I have objection. Let this matter may come after 1 week, Your Lordship.
You have objection?
Yes, Your Lordship.
Is some urgency?
Yes, Your Lordship.
1 week's time.
Yes, Ms. Air, Leonard G. Please that the matter be adjourned for 2 weeks.
1 week.
1 week, Your Lordship.
For 1 week. Yes, MS M. Hajong for the petitioner has no objection, but submits that it just seems to take up a fixed matter after 1 week.
Yes, Your Lordship.
Okay. Prayer allowed. Yes, this after 1 week.
I'll oblige.
Please, Your Lordship. Your Lordship, I beg to mention item number 21. Your Lordship, here liberty was granted to me via order 25/3/25 to file an additional affidavit. Your Lordship, I'm praying for some more time to file the additional
25
affidavit.
25
Yes, Your Lordship.
for affidavit regarding?
For an additional affidavit, Your Lordship. Because here, Your Lordship, the question of tortious liability had come up.
Is regarding the dumping of soil?
No, Your Lordship, the death of the doctor, Your Lordship, accident.
Oh, yes, 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 yes.
Yes, I'm for the petitioner, Your Lordship.
Yes. Okay, MSZ, please further out further. 1 week's time to file additional affidavit.
Your Lordship, I'm praying for 2 weeks' time.
To 4 2 week times. So to further 2 weeks time to file affidavit. Prayers allowed. At least up to 2 weeks, yes.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 29. I'm praying for 1 week's time, Your Lordship.
Yes, this matter is adjourned again and again. What
Your
happened?
Lordship, this is the second time of adjourning.
No?
Second time, Your Lordship. Your Lordship, the conducting counsel is unwell, Your Lordship. Please.
But you've been conducting all the matters.
Yes, Your Lordship, but okay,
Okay, yes.
A week may be given, Lordship. A week may be
Your
given.
Lordship.
A week may be given, Lordship.
You get up to 2 weeks for the matter, 25 matter, yes. Yes.
Oblige.
The request is after 2 weeks.
May I please, Your Lordship? Item number 22 of the hearing list, Your Lordship. Hearing already concluded, but Your Lordship was pleased to direct me to seek instruction regarding whether petitioner can be accommodated in a temporary post. But Your Lordship, I received the instruction. It is not possible.
Instruction saying?
Instruction saying that presently there is no vacancy.
What temporary post?
He was he was a multitasking typist, computer.
Operator, Your Lordship.
How many years you been working?
23 years in service, Your Lordship.
23 years.
Order already passed, Your Lordship, on 28th March.
Detailed order pass.
Yeah,
Where
order,
is the
Your
order?
Lordship, but Your Lordship was pleased to direct me to seek instruction whether she can be accommodated. So, instruction has come.
Now, service law is changing again.
This
Taken a
is the
turn also.
instruction.
There's some judgments that have come now with regard to this, who are serving for. That order was dated?
28th March, Your Lordship.
Oh, yes, long order.
Oh, yes, Your Lordship. Paragraph 4, Your Lordship, operative part.
Let's see your instructions. After using him for 23 years, data entry operator, typist, this and that, now we see his contract's over.
To without any reason, Your Lordship.
If there's any other
That
any other contractual workers appointed against this,
Your
then
Lordship,
that
under-
will be difficult for the department.
because the petitioner, where petitioner has been working for a long time, that department is also not there, Your Lordship.
What department is that?
It is a contractual appointment, Your Lordship, and agreement was also signed that against that.
It's a
petitioner
project,
cannot-
Your Lordship, but
projects
it's similar.
are for this.
No, but last time he submitted the mercy petition.
Yes, yes.
That 23
So-
years he's been working,
Yes, Your
and now he's thrown out of employment. He doesn't have any means of financial sustenance also.
My letter is also, Your Lordship, it is here. I have requested it to
Which scheme was that he was working on?
just sim- Yes, I am.
State Investment Project Management and Implementation Unit. SIMU, Your Lordship, it's under Urban Affairs.
What? Bharat mission's over.
Yes, yes. Swachh Bharat is
Close now.
It is because twice thrice notice was sent.
No,
Your
he was working project management unit of Swachh Bharat now. That Swachh Bharat's over.
It is 20 in
No,
the
he
year
was,
20.
before he was working somewhere else, then he put him. Then last he put him Swachh Bharat mission.
But the project is under Urban Management, Your Lord, Urban Affairs, Your
Whatever
Lordship.
it's no. I mean the Swachh Bharat's over. It's closed now.
23 in the year 2023, Your Lordship. It was owned up.
What to do? What is your qualification?
It's graduate.
Then we'll call out on maybe here. We'll call out the matters. We just take this back.
Please, Your Lordship, I beg to mention item number 26.
On whose behalf? NG Shilla.
No, Your Lordship, on behalf of
finish now?
SS. Yes, SS Ojha.
Who's SS Ojha? What's the matter about?
My lord, this case pertains to the non-registration of vehicles, my lord.
How long?
2 weeks, Your Lordship.
On request also. And this also 2 weeks, yes. Yes.
Team name, right.
Please, Your Lordship, I beg to mention item number 23 from the hearing list. Due to some personal difficulties, Your Lordship, I pray that this matter may be taken up after.
For respondent number 6 and 7, my lord.
What's the matter about?
This is the bifurcation of a
Please,
village,
spelling.
Your Lordship. Yes, Your Lordship.
My lord, that's
This matter also falls under the same order.
We
But
dispose of.
then the only thing is that the order was passed in 2013.
yes,
They've come in 2025.
25. Delay and latches.
Okay, how long?
A week's time, Your Lordship.
After 1 week, yes.
Yes, highly obliged.
Therefore,
1 to 4.
Mr. Yubin?
6 and 7, my lord.
Correct, 6, 7.
Supplementary list item number 4.
Yes, Mr. Bhatt.
My lord, this relates to the clerical trade in Assam Rifles, my lord. Lordship would recollect.
It's already covered.
My lord, it is already covered. The division bench also has recently upheld, my lord. But then these are the left out persons, my lord. The benefits were only extended
How many are here?
Here, my lord, 242.
242. Yes, Dr. Musika.
But
Accept notice.
this is slightly different matter, my lord.
That's what he'll always say. But when the matter comes for disposal, then it becomes the same matter.
I'll file affidavit.
Well, Mr. Dipata issue notice. Dr. N. Musika is present. Accept notice on behalf of all the respondents. No further notice called for on this after 3 weeks. Yeah.
Item number 5.
Obliged.
Yes.
Lordship, this is a similar matter, but that toll
I
gate,
think,
Lordship.
Mr. Dingdo, if there's no show cause, nothing will have, instructions
No, no.
haven't received.
My lord, that is the other case.
Otherwise,
That
we'll
is
have
new
to pass some orders.
My lord, we have cancelled.
No, cancelling, but you didn't issue notice to him about cancelling.
Yes, they have given to another person, Lordship. No, we have cancelled that also. And my lord, we have taken a decision that all gates
Where's
from
the
now
decision?
From now on, my lord, we'll see in the other matter. Item number 7. Because here we have just, this is a new case, my lord. My lord, from 2020, the same person has been continuing. No, because I was allotted, Lordship, and 21 I have fulfilled all the criteria, Lordship, getting the... That is 2 days before the model code of conduct. That is there, but, Lordship, suddenly, all of a sudden... the affidavit filed. We'll see at page 3 of my affidavit, my lord.
You've got copy of this?
Affidavit I got. Yes. Page 3, my lord, para 9, that with regards to the statement made in the additional affidavit dated so-and-so, the answering respondents state that due to the revocation of the work order of the petitioner, the executive committee, while acting as a stopgap arrangement, had entered into an agreement and has issued work order dated so-and-so in favor of Shri Drolan Thongni for collection of tolls at Maulai Moyong Rim, East Khasi district. That the answering respondents state that on 1st May, this is important, madam, the executive committee has decided to settle the collection of tolls on goods entering Shillong at Maulai and has called for application bids from interested parties. At the same time, the collection of tolls for the time being shall be taken up by the council or be stopped till the matter is finalized. Further, the executive committee has also decided to revoke the work order issued to
Where's the policy decision from executive committee?
My lord?
Where's the decision taken by executive committee?
My lord, we have annexed we have not annexed the policy decision.
That we have to see. I mean, what decision and on the basis on what? Yes. Because the basic thing is that you never intimated them that look, like we are deciding to revamp the whole thing.
No, the only thing is in their favor, the lease agreement also was issued even before it was over. 2 days before. Your Lordship will have to take into consideration the fact that 2 days before.
But that don't be the grounds for cancellation, but not too abruptly.
We have taken a decision, my lord, conscious decision. No, my lord, we will stop.
Now who's collecting now? The tolls for his goods and
it has come to an end, my lord. So we have taken over. The district council has decided to, yes.
Have you put that affidavit?
Yes, we have
not taken over.
We have stated batch at 10.
The district council officials, they came. Then he said, you have not refunded my money also as a lease fees I have paid. And you are coming and forcibly trying to evict me.
and the money also is not recovered.
Why
They
you still continue to collect now also?
How can they, my lord? It's
No,
already over. We have already revoked.
he is there, but
That
he
would
has
be- that would be illegal,
He
man.
has opened the gate by expend with a huge expenditure, Lordship.
Mr. J, what the school wants to understand is, after your order was revoked,
Yes.
now the submission of the senior counsel is that after this agreement is revoked,
Yes.
and even the other person to whom settled, that also has been
Has been
cancelled.
revoked.
Now you're still there at the revenue station.
No, he is not collecting, but he is there because he has taken the rooms and.
No, but he's still there. That means he's still collecting.
That thing I don't know, Lordship. I'll
No,
take
let
this
them
picture.
come and participate. If they want to, let them come. The district council has now called for bids.
Because
we can't allow this
as
to
your
go on.
Lordship observed that they should produce that.
We will give
the thing. They are saying that we have revoked and we have.
How much money do you pay?
2,60,000, Lordship.
And we have written
2,60,000
for the whole year.
For the whole year, my lord.
For 1 year only, March to April, Lordship. And I have paid the professional tax also, Lordship. For
Mr. I do one thing. You produce a list of all the revenue stations which leases are pending and so on and so forth. Well, let us see that.
Let all this matter be clubbed together, Lordship, which is pending before this honorable court.
But the thing is that we want to see that policy decision on the basis of which all this entire exercise being done. So we find that is not it's arbitrary.
These are political things. I feel.
But the thing is that
Political, my lord, since 2020 they have been running without calling for tenders. Since 2020, all these persons. And now
shareholding business.
So, my lord, at this no interim order should be passed. I'll produce the policy.
Just please record.
Yes.
Then we heard Mr. P.D., then counsel of the petitioner, who submits that this is similar to WPC number 153 with regard to the collecting of tolls at the revenue station, which is regarding for entry of vehicles.
Yes.
And, yes. Collection on goods entering Barneyhat area. This together with matters to be heard together WPC 153. Yes. Next para Mr. also undertake to file affidavit and to produce the records on the next date.
Yes.
Let us see them.
Yes.
Can sign my job this one here. Yes.
Obviously.
Item number 6.
Wait, please. The contempt is regarding, my lord. If your lordship kindly see the lordship's order. Why don't you arrange the file properly?
No, the only
yes, my lord.
Small issue is that
yes, my lord.
Their case is that they're working against the sanctioned posts that are available.
Yes,
and then now your state respondent is saying there's no vacancies. No, so then that's incongruous.
No,
if they're working against these vacant posts.
There are vacancies, my lord. There is no, so far as vacancy is concerned, I am not saying there is no vacancy, my lord. There are vacancies, my lord. If your lordship will see kindly page 17, the problem which we are facing, page 17 of your lordship's judgment against which contempt has been alleged, my lord. Give me 17 of the contempt contempt. Now your lordship will see paragraph 8. Accordingly, this writ petition is disposed of with a direction to the respondent to consider the case of writ petitioners by looking at vacancy position in department and to take steps in accordance with the law to consider their regularization. So, my lord, as on today, they have been working against those vacant positions. There is no dispute about that, my lord, and admitted fact is there. Now, the direction is take steps in accordance with law. My lord, if I can, law is, my lord, that we have roster. Because they are, if 40%.
Then you not put that in affidavit. Your affidavit is very blunt.
Yes, affidavit is wrong, my lord. That I have seen. I will file better affidavit because they simply cut and copy paste from the instruction which they received from the department without realizing.
But my lord, this order has to be read as a whole, my lord, not only
because there are two
para
parts.
8 in
There are
isolation.
two parts of the order. My problem is we are not against regularization. We are not having any difficulty. The problem is in twofold in the rules. One is that we have to follow the roster, and second is age, my lord. Your lordship has directed us to follow in accordance with law. Now the problem is that in accordance with law, if I follow the in accordance with law, they are all age barred. They should have filed a fresh petition where they should have, your lordship should have relaxed, because we don't have power to relax the age condition.
How many years you served?
About 2010. They have been working
more than
since
15
2010.
years, my lord.
They have been working since
15 years,
2010.
They will be age barred.
So therefore, that because I don't have power to relax, my lord, because that they should have at that point of time
Lord,
got
kindly
the
have
age
para 5
relaxation
of
to
the
that
order.
extent. Age relaxation, my lord.
Well, I'll just take your
it
lordships
is-
through the order, my lord.
And the only thing is that we will because after hearing everything, your lordship has passed in paragraph 8. Accordingly, a writ petition disposed of a direction that respondent consider the case of writ petitioner by looking up at the vacancy position in department and to take steps in accordance with law to consider their regulation. So if I take steps, my lord, I have to follow two hurdles, my lord. One, with regard to roster, because roster has to be followed, and secondly with regard to age under the rules also, my lord, the age is also there. I am carrying the copy of the rule, my lord. So therefore, and we write to the MPSC for holding the examination, and the advertisement will be issued, and then they will be age barred, my lord. That is the difficulty
What
which
about what about that aspect of special
recruitment,
even
which is done previously.
He can take these, he can put them aside. Because the thing
I
is
put that
see,
same
what
question.
has happened is these people, as
Yes.
per the order,
Yes, my lord.
see, we can't direct for organization, but the thing that they've been appointed against vacant sanction posts,
Yes,
afforded regular pay, increments, everything, all the trappings of regular employment.
And directed
No,
to take
one
part
or
in
two, my lord. Now that issue is not open for me to argue on merit.
Yes, exactly. So if
But
they are
only
serving
thing
in
is that
for all practical purposes as
that
regular
order has
employees,
attained finality, my lord. The only thing is that there was no advertisement when they were recruited. All those things are there, but those are not the issues now open for me to argue now, because this is the order which binds me, and we have accepted
Right.
the order. Now, if I accept the order, my lord, it has two parts of it, because I have to go for regularization in accordance with law, my lord, and in accordance with law. In accordance with law is my service rules. If I can place, my lord, relevant service rules which are there, where service rules and the roster point which I have to follow, my lord. That is the difficulty, my lord. If I do, I have written to the personnel department to approve the roster, because what is holding us is the approval of roster, because there are total 14 posts meant for direct recruitment. There are 15 persons who are working against the direct recruitment quota. There are total 28 posts, and out of 28 posts, 14 posts are for direct recruitment. So if out of 14 posts, my lord, then they have to have 40%, 40, and then 20-point roster will apply. For 20-point roster, we have already approved the.
Then at least the exercise should have done for
Yes, my lord. That
it could be accommodated. Accommodate them.
Yes, my lord. That exercise, your lordship, kindly give me. We will kindly give.
You file an affidavit.
Yes, my lord. Kindly give me some time so that I'll place everything, my lord. And kindly give 3 months time. I am hopeful that within 3 months time we will complete the exercise. In fact, I called the officers. I said you should have carried out the exercise, because the direction is to carry out the exercise. Please do that. So
see, why this court had passed this order also, because they're working against
yes,
sanction
I
posts.
understand. My
And
lord,
you give them
my
everything
sympathy is
from
with them only.
increments
My
to
sympathy is with
regular
them.
pay to,
Yes, my lord.
to training, to everything.
No, now the law is settled that whenever I take in ad hoc employee also, I have to pay some regular pay, some scale, your lordship.
No, but this one will go 15
Yes,
years.
my lord. They have worked for quite some time. My sympathy is with them, but sometimes law is coming in our way.
Yeah, Mr. The then Advocate General today has apprised the court that as far as certain issues that have prevented the status parliament going forward with regard to regulation of the writ petitioners, namely the roster that to be applied against the vacant posts, and also the fact that by now the petitions have been age barred. He prays and be allowed to bring on record a detailed affidavit, and also to allow the respondents some more time to try to resolve the issue. So accordingly, prayer is allowed. We list after 6 weeks.
Grateful, my lord.
Yes. Otherwise.
Yes, I understand.
Deeply.
Daily list item number 1.
Yes, you start.
May it please, Your Lordship.
Question maintainability of appeal.
Yes. Lordship, but...
Mr. Noppa, you ready?
Yes.
He's questioning the maintainability of your appeal.
Yes. Your Lordship, the appeal is... Wait, please. Your Lordship, the appeal is listed under the category of second appeals. Your Lordship, whereby the appellant has referred this appeal under Rule 6 of the jurisdiction of High Court over the Discouncil Court, Order 14. Has relied on Rule 6, Your Honor. However, in the main appeal, Your Lordship, in the cause title, Your Lordship, which is at page number 1, Your Lordship, of the main petition, the main memorandum of appeal.
Yes. Order 6.
Yes, Your Lordship. Lordship, herein he has made the subject matter of an appeal under Order 6 of the Meghalaya High Court jurisdiction over this Council Court, Order 2014, read with Article 2027 of the Constitution of India. Your Lordship, Constitution of India, Article 227 is the supervisory jurisdiction of the High Court over the other courts of subordinate courts within the state. Your Lordship, there's a recent judgment whereby, Your Lordship, any application under Order 711 file is deemed a decree, and it's not maintainable to be filed under Article 227 of the Constitution of India. Lordship, there's a recent judgment which has been delivered by the Honorable Supreme Court. So it's a recent matter with a neutral citation is 2025.
One second. Yes.
Lordship, in the question also that arise, can the High Court in exercise of supervisory jurisdiction under Article 227 reject a plain? And the observation made in Your Lordship is I'll read, Your Honor, paragraph number 8. Power of the High Court under Article 227 is supervisory and is exercised to ensure court and tribunals under its jurisdiction act within the limits of their jurisdiction conferred by law. This power is to be sparingly exercised in case where errors are apparent on the face of record, occasioning grave injustice by the court or tribunal assuming jurisdiction which it does not have, failing to exercise jurisdiction which it does not have, or exercise its jurisdiction in a perverse manner. A sense of the power under Article 227 being supervisory, it cannot be invoked to usurp the original jurisdiction of the court which it seeks to supervise, nor can it be invoked to supplant a statutory legal remedy under the CPC. For example, existence of appellant remedy under Section 96 of the Code operates as nearly total bar of exercise of supervisory jurisdiction under Article 227. Civil procedure is a self-contained code, and Order 7 Rule 11 therein enumerates the circumstances in which the tried court may reject a plain. Such rejection amounts to a deemed decree which is appealable before the High Court under Section 96 of the Code. The statutory scheme cannot be upended by the invoking supervisory jurisdiction of the High Court under Article 227 to entertain a prayer for rejection of plain. Now, here it's clearly states and observed by the Honorable Supreme Court that any application for rejection of plain is deemed an appeal under Section 2, Clause 2 of the CPC. So as such, I'm challenging maintainability that the application filed under Rule 6 of the Order 14, read with Article 227 of the Constitution of India, is not maintainable.
Okay, 227 might not be entertainable, but what about Order 6 of the High Court of Meghalaya jurisdiction to Council Court's order?
May I read it?
See, yes.
Lordship. The High Court
very wide powers.
Yes, Your Lordship.
Application of any civil or criminal case.
Yes, Your Lordship. And Your Lordship.
Decided or pending.
Yes. Lordship, since it is deemed as a decree, Lordship, the only relief that the appellant have a statutory remedy to be sought of at first instance is Section 96 before the first appellate court, and is approaching before this honorable court by way of
ladder of appeal.
I beg your pardon, Lordship.
Skip one ladder of appeal, you mean?
No, Your Lordship. That I'll come, Your Lordship, to the instance where I'm challenging maintainability. So, Your Lordship, it should be by way of first appeal under section 26 and it should come by way of second appeal in under section 100. Your Lordship, may I apprise Your Lordship on the entire facts and circumstances of the suit?
Okay, let's see the orders they've come against first. First, where's the list of dates?
Yes. Now, Your Lordship, they have instituted a suit, which is at page 11 of the memo of appeal, Your Lordship. See, it can be.
Yes.
Now, Your Lordship, this title suit number 84 is the second suit which they have filed. There was a former suit which is filed.
This is the second suit.
Yes, Your Lordship. The former suit that was filed was.
So it's not barred by res judicata also?
It's barred, Your Lordship.
Okay, no. Okay. Yes,
there was a title suit filed by the respondent, Your Lordship, against.
8422. This is the suit, the recent suit was filed.
Yes, Your Lordship. And prior to this suit, Your Lordship, the former suit was that it was registered as title suit number 19 of 1982.
The earlier suit.
The earlier suit, Your Lordship. Now, in the earlier suit, Your Lordship, the defendant, the appellant here, who is a plaintiff in the second suit, is one of the respondents in that suit. The predecessor in interest of.
Just go easy. Yes. Just slowly. The defendant in this new suit.
No, Your Lordship. The plaintiff in the new suit.
The plaintiff in the new suit was.
The predecessor of the plaintiff is the main defendant in the former suit.
So,
in title suit number 19 of 1982.
Okay. What happened to that suit?
The suit, Your Lordship, was proceed ex parte.
Against this
predecessor of the plaintiff. Against the predecessor of the plaintiff, which is defendant number 4 in the former suit, title suit number 19 of 1982. Now, observation was made in the judgment, Your Lordship. I have a copy, may I supply, Your Lordship. It was not enclosed along with the memo of appeal.
The 1982.
Yes, Your Lordship. The suit was
just continue.
Yes.
Okay, fine. You say that the earlier suit, the plaintiff here was the predecessor in interest of the defendant.
Yes, Your Lordship.
When ex parte, then what happened was the suit was decreed.
It was decreed, Your Lordship.
In favor of the predecessor of the defendant.
In my favor.
How? When ex parte against you?
It went ex parte against the plaintiff.
Plaintiff is whom here?
The plaintiff in Your Lordship is the predecessor of.
Or the plaintiff, sorry.
The plaintiff.
The plaintiff, that means non-clause client. The plaintiff is a predecessor of the defendant.
Yes, Your Lordship.
Okay, the suit went ex parte against them.
Yes.
And it's decreed in your favor.
Yes, Your Lordship.
There.
Yes. And it was decreed on 3rd November 1992, Your Lordship.
It was decreed.
It was decreed.
Okay.
And that's a different case, Lordship.
Okay, fine. No, let him submit. Then, okay.
Your Lordship,
you
I have
say that, fine.
Yes.
Okay. Now come to this fresh suit.
Your Lordship, on the fresh suit.
No appeal, nothing, no setting.
No appeal, no nothing, Your
Nothing
Lordship.
was filed, okay.
No appeal, no nothing, Your Lordship.
But the records of 1982 are here also.
No, Your Lordship, I'll come to that. Now, Your Lordship, when they institute the suit, this title suit number 84 of 2022, at first instance, I have filed an application on the Order 7, Rule 11, for the reason is that they never filed an appeal against the judgment and order dated 3/11/1992, which they are very much aware and conscious of the entire proceedings, Your Lordship. So when I filed the application under Order 7, Rule 11, Your Lordship, the trial court below, the court of the subordinate district council court, Riboy, when I filed the application and upon hearing of my application for rejection of the plain, she took the liberty to exercise power, to exercise and to go through the entire old record, Your Lordship, of the title suit number 19 of 1982. She examined the entire record, thereby she passed this order dated 6 September 2023.
Where is that?
That is at page 20.
And operative part?
Observation part is at.
Operative part is finding is. Page 45.
Page 35, Your Honor.
45.
Yes. Lordship, may I read from page 34, Your Lordship, apprising the court?
Page
34. Having regard to the averments in the plain summarized therein and the relief sought in the plain, The applicant defendant herein filed the instant application under Order 7 to 11, read with Section 11 CPC seeking rejection of the plain. The rejection of the plain was for a reason: firstly, the suit was barred by law; secondly, by limitation; and thirdly, by the principles of res judicata. After hearing both the parties, this court finds it's just to call for the records of the former suit, being title suit number 19 of 1982, which was disposed of by judgment and order dated 3 November 1992. On perusal of the aforementioned case record and judgment and order dated 3/11/1992, this court observed that the former suit was filed by Miraculous Jirwa, which may Your Lordship, I'm the respondent, and as plaintiff, entitled suit number 19 of 1982, against Linsila Jirwa, so on and so forth, and number 4, Principal Kongwir as defendants. For a decree of declaration and confirmation of right and title of the plaintiff over the paddy field and shop houses, and the defendant number 1, 2, and 3 have no right or title over the same, and so also to direct the defendant number 4 to pay the rents to the plaintiff. During pendency of the suit, defendant number 1, 3 expired. The defendant number 2, the surviving brother of defendant 1 and 3, filed petition in view of the death of so-and-so, is no longer interested to contest the suit. Accordingly, the suit proceeded uncontested against defendant number 1, 2, and 3. The defendant number 4, Kaprinciban, she is the successor in interest, predecessor in interest of the...
During the pendency of the suit, Linsila Jirwa, defendant number 1, and Keldon, defendant number 3, they expired.
Yes, Your Lordship.
Then how come...
Observation
how
against...
come the suit proceeded against 1, 2, and 3 when they say that this 2 and 3 have... Like 1 and
That's why, Lordship, the court has examined the judgment and order of the trial court.
No, what was recorded here only during the pendency of the suit, Linsila Jirwa, defendant number 1, and Keldon Jirwa, defendant number 3, both siblings expired.
Yes, and accordingly the suit...
Defendant number 2, the surviving brother, filed a petition in view of the death, so-and-so, he's not interested. That means no one is contesting the suit anymore.
Yes, Your Lordship.
Then how come according to the suit contested against defendants 1, 2, and 3?
The suit uncontested against defendant number 1, 2, and 3.
Okay. Defendant number 4 is there, that means.
Yes, Your Lordship. She has received notice, Your Lordship.
She didn't contest the suit.
She did not contest. And the reason why she did not contest the suit also, Your Lordship, the appellant here in the memo has clearly mentioned, which is at page number 4, Your Lordship, of the memo of appeal, that the deceased mother of the appellant did not take part in the title suit number 19 of 1982, as the 10 years period with effect from the date of execution of the particular document which she have relied in title suit number 84 has not expired. That is the grounds why she did not contest the suit. And she is aware and conscious of the entire proceedings of title suit number...
So now this Streamlet Jirwa, he derives interest from that, from this principal Kongwir.
Streamlet Kongwir, yes.
Oh, sorry, or whatever. Sorry, yes. Also, yes, from this principal Kongwir.
Yes, Lordship. And then, hence a judgment dated 3/11/1992 was passed wherein the plaintiff was declared to be entitled to a decree for declaration and confirmation of right, title, and ownership of the suit, paddy field, so-and-so, and the defendant number 4 was directed to pay the rent for the shop of to the plaintiff with prospective effect.
Yes.
We will first discuss upon the law applicable
now,
for...
just one thing, this suit plan is the same, Mr.
It's the same.
Mr. Noflau. It's the same.
No, Lordship.
Let me come to the prayer portion, Your Lordship.
Just one second. It's the same.
No, Lordship. The title suit number 1982 was with regard to the paddy field, Lordship. And this title suit number 84 of 2022 is again a different. It's a small portion of land which is different from the previous suit, that is 1982. So there's no connection with these two suits.
Yes, let me continue, yes.
Yes, Your Lordship. Your Lordship may come to page 11, which is the plain.
No.
Second suit, Your Lordship.
Then what happened? It ends with rejecting the plain.
Yes, Your Lordship. It ends with rejecting the plain.
That, what happened?
Against that, Your Lordship...
they appeal on 2029.
Yes, and my main contention as well, Your Lordship, that the relief that they prayed for in this title suit number 84 of 2022 cannot be granted.
No. Okay, then they file an appeal.
They file an appeal,
What
Your
happened
Lordship.
to the appeal?
Your Lordship, let me come first with the plain. I appraise Your Lordship. What if the appellant states saying that it's totally different suit land?
See,
now
if
the
we
prayer,
have to
Your Lordship,
examine that, we
yes,
have to call for the plain of that title suit number 1982.
Yes,
that's the only thing.
Yes, Your Lordship, why I'm saying that they are very much aware and conscious.
That the trial court, while passing the order rejecting the plaint or returning the plaint,
has examined the entire case record.
Is based on an examination of the earlier plaint and case records, which is not before us.
Yes, Your Lordship.
Where are the records now?
Records are still before the Council record.
In Ribhoi?
No, Your Lordship, in Khasi Hills.
We have to call for the records.
Well, Your Lordship, let me apprise Your Lordship. Persuading on my submission, Your Lordship, may kindly come to page 18 of the...
Yes.
Your Lordship, the prayer that they made here, Your Lordship, where they claim that it is a separate suit land. Your Lordship, the judgment, which is at prayer number 3, Your Lordship, page number 18. The judgment order dated 3rd November 1992 is only with regard to the paddy field, etc., but it is not with regard to the suit land.
Yes.
Your Lordship, even the prayer here in such a manner, circumventing the entire draft, Your Lordship, to bifurcate the only judgment decided when they have not preferred any appeal or revision or whatever application before the higher court.
That's what we have to see, Mr. Lingdo, that they have come against the judgment of the appellate court, upholding the judgment of trial court.
Yes, Your Lordship.
So that is what we have to see. Now, where the finding of that appellate court, what does it say?
And Your Lordship, observation was made before this, the trial court, that they have failed to make any application and have filed a suit after a period of 35 years, which by itself, Your Lordship, is barred by limitation.
Where's the final order in this appeal?
It's at page 78, Your Lordship.
78. Yes. So they have held the trial court. Yes, concurrent findings. Anyway, we'll call for the records. We'll hear it. Yes, in the course of hearing, it appears that the records of title suit, we'll just compare for our satisfaction.
Your Lordship, may I have a note that I've prepared in accordance with the entire...
No, we don't have a note. Do you have a copy of the plaint? You can supply. You don't need to call for the records.
No, Lordship.
1982 plaint you have?
I'll have to seek instruction on that, Your Honor.
No, do you have a copy of that plaint of...
I have only copy of the judgment, Your Honor. The copy of the plaint, I have to seek instruction, they have or
Then we'll
not.
call for the records. In the course of hearing the matter, in the course of admission hearing of the incident matter, it appears that the order of the learned trial court was hinged on the records of TS number 19 of 82. Stop. As it appears that the plaint is necessary for examination on the ground of res judicata, that the records be requisitioned from the district council court. Please immediately after receipt of records. Yes, sir. We'll see. And the chart point also.
Item number 2.
You should have got a copy of the plaint. Then it would have been simpler if we are saying that the part res judicata, the whatever.
And Your Lordship, also the document they relied in title suit number 84, it's against a co-defendant, not executed by me or in whatever manner. Highly obliged.
Obliged.
Yes.
Item number 2.
Yes.
Please, Lordship. Lordship, I've just received the affidavit. Your Lordship, if required, I'll file my rejoinder accordingly.
Just received just now?
Yesterday, Your Lordship.
Okay. Yes, also receiver of case for allowed. Which time to file? Oh, she submits that after just been received. Please time to file the joint if necessary.
Obliged, Lordship.
If found necessary.
Item number 3.
Where is that? May it please Your Lordship.
Yes, Mr. Shuraya.
Lordship, in proportion to the last order, Your Lordship, we have filed the affidavit, Your Lordship. We have brought into record, Your Lordship, the the report of the inquiry, Your Lordship. If Lordship kindly come to page 22.
Yes.
Lordship, kindly see, in the light of the above statement, it is hereby recommended, in my humble opinion, to dissolve the current SMC of Rajabala and to appoint a caretaker management body under the Education Department to oversee the conduct of fresh election unmarred by malpractices and controversies, to let the children suffer, to not let the children suffer and their future be at stake while the mess created by the current and erstwhile money committee is to file criminal so-and-so, Your Lordship. So, Your Lordship, the department has accepted this report, Your Lordship, and now the process is at the stage of issuing show cause notices to the present money committee, Your Lordship. Then, after receipt of the reply, Your Lordship, a decision will be taken accordingly, Your Lordship.
So, Mr. Paul, you don't have any more quarrel?
The quarrel only remains as, my lord, what we were saying. Apparently from the report, my lords, it seems that there's something not correct going on in the school.
Yes.
That's apparent, my lords. If your lordships kindly have a look at the second paragraph of page 22.
Yes.
There seems to be no excusable merit in the response of the SMC with regards to the delay in conducting the interviews. The entire process and lapses seek abandonment of due process in a hurried, botched up attempt to fill up the vacancies. The possibility of foul play and illegal gratifications cannot be ruled out. If my learned senior is saying, my lords, that they are in the process of issuing show cause, would only pray, my lords, let this matter come up after 2 weeks. In the meantime, whatever progress would be there, we can apprise this honorable court. It should not be, my lords, that once this matter is closed, what usually happens, everyone goes to sleep and everyone forgets, my lords, what's happening.
Lordship, kindly see
the court-monitored kind of
I'm not asking for a court-monitored probe, my lords. What I'm simply saying is, since they've said, my lords, they're issuing a show cause notice, I'm simply saying let this matter be adjourned for 2 weeks. In the meantime, my lords, if things are progressing, we'll close the matter.
Yes, Mr. Hassan.
For respondent 6 and 7,
You're the SMC?
No, my lord. We are the parent guardian, my well-wisher of the school. We filed the complaint, my lord.
There are also other complaints.
What about the
Lordship, in the next item,
you appear in management committee, Mr. Nongpur? No, I mean, like, who's appeared? Who's number 5? Hadisul Islam.
Is the secretary, present secretary of the school, my lord.
Who's representing him here?
They have not appeared, my lords. They're not entered appearance.
Akas Ali?
Somebody is there, my lords. Mr. M.U. Ahmed. Somebody, Mr. M.U. Ahmed, had appeared, my lords.
But he withdrew himself. Withdrew himself.
Yes.
No, my lord, he did not withdraw, my lord, but he has not been appearing any further.
Thereafter, he has not appeared, my lords. No, he has appeared quite a number of times.
Same person, Akas Ali, is also respondent and respondent 5 in the next item.
You are representing him.
Basically, I'm representing the school management.
What do you have to say with the report?
Copy has been served upon us. Government takes steps on that.
So you have no quarrel with that? Okay, yes.
Let the matter come up after 2 weeks, my lords. Things will become more clear.
So, in my humble and respectful submission, Your Lordship, so far the present rate petition is concerned, Your Lordship. In my humble and respectful submission, Your Lordship, it become infructuous. Lordship, kindly come to page 13, the prayer made in the rate petition.
No, I'm not disputing that. I'm not disputing that, my lords, at this stage. I'm only saying that since they're saying that they're going to proceed further with the inquiry, I said let this matter come up after 2 weeks. We'll know what is actually happening.
Action should be taken on the inquiry report, my lord, by the state government.
It's a tall order to scrutinize the books of last 10 years.
Yes,
magnitude embezzlement.
Yes,
What is astonishing in this report as well as what I didn't want to point out is that they find so many anomalies with everything going on in the school for the last 10 years, yet not a single government functionary, any responsibility with the DSEO is fixed. So either, my lords, the DSEO has no control over the affairs of the school or somebody is shielding him.
The DSO is the part of the recruitment process, my lord.
Now we are taking care, Your Lordship.
Which is why I submit, my lords, let the matter come up after 2 weeks.
it'll become clear, my lords, what the government is actually contemplating to do, and if they are actually taking any action.
No, I think that's fair enough.
Lordship, yes.
Yes, Mr. Andy Shulai, when the matter is taken up, has drawn attention of this court to the affidavit file on behalf of the respondents.
Same order
Number?
Lordship, this is
124.
Lordship, yes.
124.
124, wherein an inquiry report with regard to complaints against the managing committee members of Raja Bala Higher Secondary School, West Garo Hills, has been annexed up. Next by Mr. Dalan AAG has submitted that as per the findings of the inquiry, it is seen that as per the findings of the inquiry, it appears that certain steps have to be taken which have been recommended in the said inquiry report itself, such as to dissolve the present managing committee and for appointment caretaker managing committee, apart from other steps which include filing of criminal complaints to arrest the embezzlement, filing criminal complaints, etc. Stop. In the view of the matter, he further submits that as steps have been taken by the state respondents, the matter has since been and same can be closed to leave the response to take appropriate action on the basis of the inquiry report. So, next by Mr. K. Paul for the senior counsel petitioner, however, submits that the matter be adjourned to 2 weeks so that the court may be apprised on the next date as to the steps that have been taken pursuant to the inquiry report. So, Mr. S. K. Hassan for respondent number
6 and 7.
6 and 7 concurs with submissions made by the senior counsel staff. Mr. Nongpur, as also Mr. Nongpur, who is representing the respondent number 5, not a connected matter. So accordingly, it is expected that the state respondents shall take immediate steps to initiate appropriate action in terms of the inquiry report as expeditiously as possible. It's a matter for 2 weeks for the order. Yes.
Same order in item 4 as well.
Same inquiry report.
Yes. There, my friend Mr. Nongpur is appearing for respondent number 5.
Item 4, Lordship, the petitioner has challenged the advertisement, the recruitment process, Lordship, which was carried out by the.
We just list the next one together. Not see anything else.
That covers in that, my lords.
Yes, we'll list it together so that we won't have.
I'll oblige.
Item number 5.
My lord, 5 and 6, I have received the instructions. I am seeking for 3 weeks' time for.
No one's appeared for the petitioner.
Mr. Bora is there, my lord. I informed him.
Will you file affidavit?
3 weeks' time, my lord.
Mr. None appears for the petitioner. Mr. Arguru appears for 3 weeks' time for affidavit.
5 and 6. Deploy.
7.
Yes. This matter, the state is still yet to file
Please,
their
Your Lordship. Your Lordship, just 2 weeks' time, Your Lordship, I'll be filing
Just
my
2 weeks'
affidavit.
time. How many
Yes, Your
times you've asked?
This will be the 6th time.
Your
Sixth
Lordship,
time?
I was in bereavement, Your Lordship.
Yes. What is the matter about?
Compassionate appointment, Your Lordship.
Yes, MS Ivaranga prays funds allowed for the 2 weeks' time to file affidavit. So she submits that the affair could be filed till they are due.
Last chance will be given. Last chance.
Yes, stop is expected next year. The affidavit should be on board.
Much obliged.
Obliged,
Lordship.
8.
Lordship, we have just received, Lordship, the affidavit filed by
It's fine.
respondent. 5 and
That's
6.
Mr. Pasantia. Why are you hiding there? She said that they could not travel to Shillong. They finally managed to travel. Yes.
So we will be filing the rejoinder, Your Lordship. So we are praying for time, Lordship.
The course of the day?
No, Your Lordship. 2 weeks time.
2 weeks time. It's a positive service that the affidavit in 5 and 6 has since been filed. Stopped. Mr. Naita for petition brief for 2 weeks time for rejoinder. Yes.
Authorized, Your Lordship. 9.
May I
You
please,
see
Your
status?
Lordship? Yes, Lordship. Some more time to file the affidavit of service, Lordship.
What about 124?
Can you grant some more time, Your Lordship, to file an
What's the
affidavit?
matter about? Nochmal?
Nogma matter, Lordship.
MS also for the petitioner. MS G Sech Marak, correct?
Yes, Lordship.
Yes, for the petitioner. Where's that report? Praise for further 1 week's time.
Yes,
to
Lordship.
file affidavit
Yes, Lordship.
indicating service upon respondents 5, 6, 8, and 9. Stop. MS S. Dahar, neighbor on behalf 1 to 4. Also praise that further 2 weeks time be
Your
given.
Lordship. For respondent 7, Your Lordship.
You also want 2 weeks time? Or you're not filing affidavit?
Need some more time, Your Lordship.
Yes, and MS Idahar for 7 also praise for 2 weeks time. So covering this matter for 2 weeks for
Highly
affidavits
obliged, Your Lordship.
for all the respective parties.
10.
Yes, affidavit file.
Lordship, so far the state is concerned, we file, Your Lordship.
Lordship, the respondent 1 and 2 are yet to file, Your Lordship.
Yes. Number?
1 and 2.
How long is it going to take? It's a fresh filing, correct?
Yes,
Yeah, 2 weeks for the time. Mr. Enishulai on behalf of 1 and 3 to 12 submits that affidavit has been filed. Stopped out Musica. However, on behalf of 1 and 2 praise for 3 weeks time. Prayers allowed this for 3 weeks. Yes.
Apply, Your Lordship.
11.
My Lord, yesterday we have already served the copy to the petitioner, but then due to some technical error, we couldn't file the affidavit, my Lord. So I'm seeking some time.
Yes, spirit for the 1 week's time allowed for affidavit. Yes. 1 week enough?
Kindly give us 2 weeks because we need to, because we need to get the signature from Silchar, my Lord.
2 weeks, okay.
Highly obliged, my Lord.
12.
Lordship,
Your Lordship, state has filed an affidavit.
I pray for 1 week's time, Lordship, to file my rejoinder.
You already prayed last time also.
Yes, Lordship. This is my second, Your Lordship.
Mr. Kera, not filing.
My Lord, we are not filing for the school, college, Synod College.
Yes, further 2 weeks time is prayed allowed to request for rejoinder the affidavit filed by respondent 1 to 5.
Yes, Your Lordship.
Right, Your Lordship.
Obliged, Your Lordship.
Obliged.
Lordship, here I have filed the affidavit. But, Lordship, there are 2 claimants in this case. So there are 2 wives. So each claiming they are claiming for the pensionary benefits of the late incumbent. So they have submitted the representation, both the petitioner and the second wife.
You made the respondent the other wife?
No, it has not been made. So second wife may also be made party in this case.
They have to file an application.
Yes. Let them.
You understand what is happening? The thing is that there's another claimant, which is the second wife of. You say that you are the legally married wife of the deceased.
Yes, legally married wife of the deceased.
Columbus Walang.
Columbus Walang. Annexes 6 and 7 are very important, Lordship.
Affidavit.
Yes.
You've seen the affidavit?
My lord, as the conducting counsel is out of station.
Who the conducting counsel?
As non say LAC.
Who?
As non say LAC matter.
You just note what submissions is being made by the government counsel. Okay.
Kindly come to Annexure 6, Lordship.
Only that Mr. Sangma, where's 6 and 7?
Yes, Annexure 7, page 17. Page 18 is the translated copy.
So you take the order, then you. Yes.
This is the representation made by the second wife.
Yeah, this is, what's her name?
Pildaris
Amora.
Yes, Pildaris Amora.
Yes.
And Annexure 7, Lordship, one more. Annexure 7 is also very important.
Just record that.
Annexure 7 is a joint petition submitted by the family members of late incumbent in support of the claim made by the second wife.
Okay. Take down Mr. M. Sangma. Leonard G.A. has submitted that in fact there are two claimants for the terminal benefits of the deceased employee. That is the petitioner and a certain Srimati Pildaris Amora, who is not the made party. What is your name?
Arpachang.
MS Arpanchang, appearing for the petitioner, responds allowed to obtain instructions for implement of the alleged second wife. Yes, it's up to 2 weeks.
Oh, that's awesome.
14.
Yes.
May I please, your lordship? Here we will file the affidavit of service.
Complete.
Lordship.
Complete.
Yes, lordship. It's shown complete, lordship.
MSG Marax submits that status of service and response 2 to 4 has been received. It was allowed how much time?
1 week, lordship.
1 week time to
file affidavit.
To file affidavit indicating service. Yes.
Problem.
15.
It is, your lordship. Your lordship, in this matter, on the last occasion, the state was supposed to bring on record certain objections.
It is, lordship. I pray for 1 week's time, lordship, to bring objections.
Becoming a journal master for the
Lordship, there were some problems with the
case.
Lordship, my apologies, Lordship. There were some problems.
After raising preliminary objections, you said you put them down.
Lordship, I pray for just 1 week's time, Lordship. On the next day, I'll.
Your submission only that the preparation will be entertained.
Lordship, I pray for just 1 week's time, Lordship. There were some problems with the.
Yes.
Lordship, service has also been, a notice has also been affected on the private respondents, if I may be allowed to bring that on record as well.
We are applying for number 7, my lord.
7 whom?
My lord, kindly see, my lord, this repetition.
Performer.
The performer respondent, yes, your lordship.
Yes, Dr. and Mosika films in behalf of the performer for number 7. Stop. What about 6?
Service has been affected, your lordship, if I may be allowed to bring that on record.
6, stop. On behalf of number 7. With regard to performance on number 6, it is submitted by LCM that service will be affected and affidavit indicating service will be filed. Stop. Mr. H. Karanlang, however, on behalf of the state respondents,
Lordship, 1 week's time.
Wait 1 week's time to allow for what?
For objections, Lordship, on maintainability.
Written objections.
On maintainability, Lordship.
Lord, maintainability, my lord, kindly see the prayer, my lord. The writ petition is
fine. Second petition.
Yes,
but otherwise also they are seeking section 64 reference under land acquisition in respect of 2010 land acquisition.
Yes, your lordship. That is there, your lordship. But we have not been able to acquire the latest notification, your lordship, and we filed RTIs based on that.
The case will turn its own facts.
16.
Yes, your lordship. Highly obliged.
My lord, I'll be representing SAIL.
SAIL,
my lord.
Yes.
We are the employers, my lord. We were the ones who have given them the contract.
This is the second case along similar lines.
My lord, it's the second case. First, I think it was with Pioneer. Industries. My lord, however, there is my initial instructions are, my lord, because we have not received a copy of the petition as yet. My lord, that there is a contract which exists and there is an arbitration clause.
You kindly supply a copy of the
I'll give a
petition,
copy.
and we'll have it next week.
That's what we're saying also. These matters have to go in for arbitration.
Yes.
That's been settled by the.
Mr. N. Khera has entered a parent study on behalf of the respondent's number.
2-2.
Number.
Well, it's 5-2.
Sale will be.
Sale, my lord. I don't have a
2-2.
Yeah, I'm sorry, well, it's from respondent number 2.
18.
All of them.
My lord,
19.
2 to 19. My
2 to 19.
However, he submits that he is yet to receive a copy of the petition. Only petitioner is ready to supply a copy of the petition within
2 days. By tomorrow, we'll ensure that.
This matter after 1 week.
Well, it's the interim orders may be
Interim order shall continue.
My lord, 2 weeks, my lord. There's a
2 weeks.
occasion in the chamber. Obliged.
Interim order then shall continue.
17.
Please, Your Lordship. Lordship, this is that golf matter, my lord. On the last occasion, Lordship was pleased to grant me an opportunity to file a show cause or small affidavit.
Where is it?
My lord, it's been signed, executed, notarized and dispatched from Delhi. Unfortunately, my lord, today I still haven't received it. I expect to receive it by end of day today or by maybe tomorrow. If Lordship allows me 1 day's time, I'll place it on record. All I have, my lord, right now, I've shared a copy with my friend also, a scan copy.
They've given me a scanned copy, but that affidavit's not on record as on.
So what are we to do then?
If Lordship allows a day's time, by tomorrow I should be able to file it, my lord. It can come up on Monday if Lordship chooses.
Monday is a holiday.
Oh, sorry.
Tuesday.
We'll have it on 15 then. To keep it on safe side.
Very good.
Yes, Mr.
Well, may I pray for 14th, will
14th bit difficult. Court might not be available.
15th is Thursday. 15th.
Mr. S. Jindal for response 223 submits due to inadvertent circumstances, the written objections could not be placed before the court today. He, however, submits that a copy of the same has since been served on the petitioner's society. Accordingly, this is matter on 15th.
Well, Lordship may also kindly grant me liberty to file a reply to this. Well, in the meantime, I can also file a reply.
Before it's come on record also? I don't think so. That'll be
proper.
Suppose the court wants to, sees that this it can cut it short. Yes.
Well,
this on 15th.
Hearing 18.
Yes. So now we will give a decent burial.
My lord, a decent burial is indeed honorable, my lord. Yes. A decent burial would be also honorable, my lord. Yes. But then it has to be decent, my lord. What we had been, my lord, I had confined myself to a very limited point.
One last rites or decent burial?
Yes, my lord. I had confined myself to a very limited point, my lord.
Yes.
Here. The Fifth Pay Commission, my lord, was what was directed to be implemented. Fifth Pay Commission, my lord, knows that the Pay Commission is for enhancement of pay. It is never for a reduction of pay. So, we were entitled, my lord, to a class-wise benefit, class 3, class 2, class 1. For others, my lord, a class 2 benefit also was granted. For us, we were only confined to class 3. That I understand, okay, if I am not given class 2, that might be, my lord, a separate cause of action. But then while conferring the class 3 benefit of Havaldar to us, the ministry in its initial approval, my lord, had said that the ministry, my lord, on 2nd January 2024, sorry, my lord, on 23rd October 2025, then that is when the SLP was pending. They say that you implemented by 23rd October 2015.
Yes.
They say that the cases are approved for upgradation and redesignation of the rifleman ORL in the rank of Havaldar ORL. Now, even this was fine, my lord, because that entitles us to financial benefits. But then without consultation of the ministry, after the SLP was dismissed, the Assam Rifle, without referring the matter to the ministry, had issued, one colonel had issued the order on 23rd August 2016, whereby it was said that the word upgradation should be read as promotion, my lord. So that destroyed the entire financial benefit, and rather than benefiting from pay commission, our pay has gone down. Now my contention, my lord, here limited contention here is that, my lord, even though contempt jurisdiction is very limited, the Honorable Apex Court very recently also had summed up the powers of contempt in the decision that I had already placed in the case of Balwan Bhai Soma Bhai Bhandari. If your lordship has a look at para 116, the third direction.
The main contempt section.
The third direction, my lord, says, although the transfer of the suit property pendant light may not be termed as void ab initio, when
the thing is that, see, whether, you know, the upgradation, redesignation, so and so, that whoever ORL is saying,
my lord.
Now, that requires, again, you know, substantive kind of
Malad, all I want
discourse.
Is there cannot
contempt
be
rightly. Now, what do you want to show? Sorry,
Malad, it says subsequently after discussing the fact, the last second line, my lord, it says that apart from punishing the contemptor for his contemptuous conduct, the majesty of law may demand that appropriate directions be issued by the court so that any advantage secured as a result of such contemptuous conduct is completely nullified. This may include issue of directions either for reversal of the transactions by declaring such transactions to be void, or by passing appropriate directions to the concerned authority to ensure that contemptuous conduct on part of the contemptor does not continue to ensure the advantage to the contemptor or to anyone claiming under him, my lord.
Who just
so
this?
Patiwala. So what I, my lord, to confine myself to is that the second order which has come by the Assam Rifles without approval of the ministry, and interestingly, my lord, the ministry till date has not filed any affidavit on this matter. Even the DG has not filed, his junior has filed, who is not a contemptor, bringing in the facts. So this issue, my lord, is what I am stuck on as of now, my lord. That this court can definitely make an observation that what you had done without approval of the ministry subsequently, by nullifying the entire benefit of the judgment after the SLP was dismissed, it appears to be prima facie contempt. They would definitely know that this order has a consequence of reduction of pay rather than enhancement of pay as per the Pay Commission's directions.
No, I mean, again comes to the same thing, Mr. Pathak, like you're asking for uniformity,
my lord.
Right?
My lord, may I intervene here, my lord?
I'll just conclude in one line.
It'll cut short many things, my lord. My lord, the order which they are seeking to implement, my lord, so seeking to enforce, there are 2,000, some odd number of petitioners, my lord. There are some 2,000 petitioners in that writ petition, my lord. Some of the writ petitioners, my lord, they did not wait for these contempt proceedings, my lord. They, in fact, filed substantive writ petitions before this honorable court. That is WPC number 418 of 2024.
That is the name of the party?
Satish Kumar versus Union of India, my lord. That writ petition has been allowed by this honorable court. Writ proceedings, my lord, for this, and I have instruction to file an appeal against that, my lord. So, my lord,
418 was order. You have to pass by this bench itself.
By this bench, my lord.
You are a counsel?
No, Mr. Chanda is probably the counsel.
Chanda is the counsel. Do you have that order?
I have come across it, my lord. That order was again passed in terms of the orders that are passed for the ciphers. Now the orders that have been passed in favor of the ciphers, they are also, my lord, not being implemented. Contempt proceedings are pending both before this court and the Guwahati High Court, my lord.
So, my lord,
So
in my
nothing
humble
is,
submission,
as far as that is
some
also
of them,
concerned, nothing is conclusive as of now.
my lord, some of them have availed the proper remedy, my lord, and some of them are still pursuing the contempt proceedings, my lord. So in that view of the matter, this honorable court has allowed the writ petition, my lord. I have instruction to file an appeal against that. So in that view of the matter, my lord, where will this contempt proceeding lead, my lord? They have to follow that route, my lord. That's my humble submission.
No, that we understand. That the only thing we see is very limited whether direction be passed. That's why Mr. Pathak has taken the pain of bringing out a direction that, bring out a judgment where you've seen the judgment, correct?
No,
that says that, includes issue of directions. Anyway, with due respect, my lord.
But here the facts are slightly different, my lord.
Maybe we'll not even have to go to that extent. I appear in the next matter. Lordship, just permit me. There's one affidavit which should settle the entire matter. This is an affidavit filed by the Sun Rifles. It's not an affidavit, it's an application. In item 19, my lords, this is an affidavit that was filed on.
Otherwise, you see, when everything becomes cloudy, then to make out a clear case.
That's why I'm referring to just, which is why I'm referring only to this affidavit.
Mr. Paul, you know very
well. We need not even get into the disputed questions of fact or whether there's violation or not violation. Only reason, Melaz, I'm pointing out this will settle the entire matter. This is affidavit. This is an application filed on 22/10/2018.
22/10/2018.
This was miss case number 2 of 2018. Legal sought extension for compliance. Now, what happened in this miss case as well is, while your lordships get the records, they filed an application seeking extension of time to comply with the judgment and order. And interestingly, Millets, if your lordships kindly have a look at paragraph 3 at page 3
of the application.
Millets. This application is filed by Millets. He was SO1 legal at that point of time when this application was filed. And this was permitted by this court. Paragraph 3, Millets, they say that the applicant state that pursuant to the orders passed by this honorable court, the applicants have taken appropriate steps to initiate the process for giving appropriate rank and pay scales to the petitioners as per the 5th Central Pay Commission and Office Memorandum dated 22nd January 1998, including financial upgradation under modified assured career progression scheme of the Government of India. In this regard, MHA, after consultation with the Ministry of Law, so-and-so, dated 10/9/18, asked the Assam Rifles to submit a complete proposal for implementation of the judgment and order dated so-and-so with approval of the DG so-and-so along with financial implication. While so-and-so requested to seek extension of time. Then next, Millets, in paragraph 4, they lay out, Millets, the financial implication. They say it's 66.24 crores. Then paragraph 5, Millets, they say the calculation of the total financial implication was again rechecked and verified by so-and-so, and thereafter by letter dated so a single file containing all the relevant documents along with total financial implication was forwarded to MHA.
Yes, Dr. Mozika is filed by you only.
That's what I'm saying, Millets. So now the case before your lordship says...
Separate cases, my lord. Mr. Paul is appearing in the next item, which is with regard to ciphers, my lord.
Ciphers is done. Actually, ciphers now, the only thing they're seeking to complicated, but ciphers is done. Is it done for you?
Which is what I'm saying. If there is an application saying that there's financial upgradation,
even by repeated judgments of this court, so ciphers is done.
Cipher has been implemented. I do not know, my lord.
Which is not in,
insofar as we are concerned, my lord, the petitioners before your lordships are concerned, it's not been implemented.
That means that that they have to ensure that the orders are all complied with.
Absolutely, my lord. Prima facie case of contempt, because they say, Malad, 66 crores is the financial implication. Now, the petitioners before your lordships are saying, Malad, we are rather losing out than getting any money. So, where is the 66 crores going?
My lord, this contempt application is filed in 2015, my lord. So much of water is flown down the bridge after in the last 10 years, my lord.
You say we are taking money from the central government. Thereafter, my lord, can you take a U-turn in 2025 and say that so much water has gone through?
Mr. Paul, is that is a contempt application. We can't make sweeping observations. We can't make sweeping observations.
My lords, I'm not on any sweeping observations.
Exactly, no.
We've filed an affidavit bringing on record.
Violation or non-violation, compliance or not. The only thing is that
No, my lords, what I'm trying to, if your lordship just bear with me for a minute, what I'm trying to bring home is, my lords, they say there's financial implication, meaning thereby, my lords, that Union of India has to pay us. We have filed a detailed affidavit clearly showing that if somebody was getting 10 rupees yesterday, my lords, in the garb of compliance of this order, I'm getting 4 rupees today. So where is the compliance?
That has, several orders have been passed by your lordship, my lord, in those matters. So
in which appeals are going?
My lord, Mr. Pauls would file an affidavit now clearly stating as on today whether they are deprived of any of the orders passed earlier, my lord. But we're still hinging to something.
Everything is
everything is resolved, my lord.
My lords, it was covered the day SLP was dismissed. That was in 2016.
Yes. No, it's covered. I mean, even repeated cases have come. Other states have been included. Storekeepers also have come.
It's totally been
2016, my lords, this was done. And we're standing in 2025.
My lord, they should take instruction from the client, file an affidavit. As on today, are they, whether the orders have been implemented?
No, any longer. It is serving no purpose.
Well, I have not got the benefit. Others have not been before your lordship.
I mean, no, there's no purpose in the contempt. You can file for implementation, but in contempt, that's the only thing.
My lords would kindly appreciate.
Taking this miscase into
consideration.
My lords, can cut short the entire matter.
Which is what I'm saying, my lords.
In a proceeding.
No, which is what I'm saying, my lords. That if these people,
we can't pass directions now. We can't record and say. The only duty of the court now is to say whether this.
It's been complied or not.
Yes.
Now what is
he's saying no? He's saying yes.
He's not saying yes, my lords. If he says yes,
he's saying yes. He'll show the amount of.
No, he's not saying yes, my lords. He's simply saying that let us seek instructions as to whether we are still deprived or not. If I'm not deprived, why am I before this
orders?
My lord, last affidavit when we sought extension of time, that was in 2018, my lord. What my friend is referring to, my lord. Even from that date is 7 years, my lord. They should clearly specify now as on today, my lord, whether the cause of action still survives.
See, making it very difficult for this court. It's not a
my lords, my lords, I had very frankly submitted before your lordships, my lords.
Just take how many petitions?
The original writ petitions, my lords, went right up to Supreme Court, contested, decided in our favor. Thereafter, my lords, we come back before this honorable court in contempt. They file application seeking extension. What my friend was pointing out, my lords, everything was being done. Then somebody comes, my lords, very intelligently changes one phrase. From upgradation, it becomes promotion. Redesignation, it becomes promotion, upgradation. That's where all the problem starts.
Corrected by other orders.
But not implemented in our case.
Well, that's not correct, my lord.
If it had been implemented, my lords, the repeated writ petitions would not have come before your lordships. This contempt would not have survived. And then, my lords, to come, my lords, if I were to take the other route, what my learned friend is suggesting, if I am to take the other route and come in a writ petition, the writ petition will take some time to dispose. We'll go in appeal. We'll go to the Supreme Court. What they basically want is, my lords, what the state is basically doing is they want to fatigue out the petitioners, saying that you can fight as much as you want, you can go to as many courts as you want, you can win as many cases as you want. We'll not give you the money. This is what is coming out, my lords. If an affidavit is filed seeking extension of time 65 crores.
There are ciphers for the case that they have not been paid now also.
My lord, lordship passed a series of orders. Asim Devra, lordship, remember, everything has been settled now in case of ciphers, my lord. By way of substantive proceedings, my lord. Substantive orders have been passed.
Petitioners here also.
Oh, there's only one contempt petitioner, my lord. But they should find out whether others have been implemented or not, my lord.
Well, it's because
there are 700 people, my lord.
These were batch petitions that were filed.
Contempt is filed by one person, my lord.
There's
one person.
One person, but because of the simple reason, my lords, because everybody was posted in different places.
Of course, no, that we're not looking into that. We're saying whether,
what if your lordships permit me, what I can probably do is, my lords, I can prepare a chart. No affidavits required, my lords. What we were getting earlier, what we are getting now, what is the difference that has happened in this, that I can file, or in respect of all 700 petitioners.
Only one.
You file for, if they file for one also on affidavit that they have not received, my lord, we'll respond to that, my lord.
Some other contempts relating to the ciphers are pending here, my lord.
We're in Guwahati.
Here and also in Guwahati.
It's not, but your lordships would kindly appreciate, these are simple people, they're the members of the armed forces. Why would they be, my lords, pursuing a matter before a court?
But as far as the first matter, my lord, Mr. Pathak's matter, my lord, in my understanding, that should be closed, my lord.
No, in my case
other
also, my lord,
half of the other petitions, my lord, they've come by way of writ petition, my lord, before this honorable court.
Which is also, they say, will be taken to appeal, my lord.
So that is to be decided in
At one
petition or
point
writ
of
appeal, my
time,
lord.
when the matters were before Justice Rafiq, a chart, in fact, of what will be the financial implication was submitted
that
by the
chart?
Assam Rifle. That is there on record, my lord. That chart. Thereafter, my lord, COVID came and the matter got deferred. But in our case also, in the contempt also, when the writ appeal was pending, there was a submission made, my lord, the last page of our contempt application,
My lord, the fact
page
that-
196.
my lord, the very
they
fact,
again
my
say
lord-
that we will amend everything, including the recruitment rules in consultation with the ministry.
My lord, the very fact that the contempt petition has to be argued for half an hour, my lord, that in itself shows, my lord, there is no contempt, my lord.
So that
And
itself can
moreover,
also show, my lord,
coupled
that
with the
there
fact,
is
my
some
lord,
mischief.
coupled with the fact that this is pending for 10 years, my lord.
Because when the writ
Contempt
appeal was
petition is normally this is the order not complied with, my lord.
the writ appeal, when it was disposed, my lord, in my case, there was an observation that the issue as to whether proper compliance has taken place or not will be independently decided in the contempt. No, my lord, and the writ appeal in this matter, my lord, was decided. So that is why the contempt survived.
Which page referring to 195?
I'm referring to page 196 of my contempt application, my lord. Here, my lord, they say that we have to do everything in consultation with the ministry. And therefore, it is taking some time. Now, in consultation with the ministry, they come up thereafter with an order.
That's
But
a
then thereafter, my lord, without consultation with the ministry, the order is
That's
changed.
a 10-year-old order, my lord.
Order is an order, my lord.
13,
It has not
5
been
to
reviewed,
15,
neither
my
been
lord.
changed, my lord. It stands still today, my lord.
So in this order, ask for compliance in the first week of August.
My lord.
2015.
My lord.
You seen this order?
We have complied with what we are saying, my lord. They're entitled to Hawaldar that we have given to them that at that point of time itself.
Hawaldar we have been given, but then the manner in which it has been given.
Now the
my
manner
lord,
requires, my lord,
is-
whether the
is-
manner is correct or not, my lord.
Let's see the 15 order. 23, 10, 15. And you're going through the same thing all over again. Yes. Now we see 56. Because the messes of the songwriters making only. Because the
Well,
memorandum
definitely it's a
notification
mess,
said
my
only for 2-3 trades. But then by
My lord, because of the contempt, my lord, we had to implement for some more, my lord.
What I am pointing out now is, my lord, that there cannot be two compliances. Initially, if you are compliant, we are happy if that is the compliance, my lord. How can you now say that, no, we have recomplied it, my lord? And that too without approval of the ministry. If the first order is treated as the correct order, my lord, that is fine. If that is the compliance, we are happy with it, my lord. The other part as to the class-wise, my lord, rank, that we can hesitate in a writ petition.
what to do?
My lord, my ambassador, the matter should be closed, my lord. And they should be given the liberty to file a writ petition if they want, my lord. Like the others have come before this one. Same petitioners, my lord. Here also contempt is filed by only one person, my lord. The writ petitioner were 2,200 something. They're saving a lot of court fee also.
Like Mr. Paul said, simple people they should have simple savings also.
Simple people, and the simple means are also deducted.
That's why they didn't want that promotion, upgradation, because that's why they were getting less.
So,
But that's been rectified by lordship.
That's been rectified, yes, but then
That's
after you
rectified.
doing recovery also from the pension.
That's when people have to come before this honorable court.
That has been
get their
rectified.
orders.
my lord, after that order also, it has not been implemented. The contempts are still pending, my lord.
They're still deducting?
Deduction has stopped. But then, my lord, the other benefits, ancillary benefits of refund of the money.
Guwahati High Court, I know in this court there is no such contempt pending.
No, there are.
Or why the matter is pending for Guwahati High Court?
Contempt is pending, my lord. Implementation has not been done. So recovery has been stopped. In fact, your lordship had initially passed an order of stoppage of recovery. Thereafter, everybody's recovery was stopped. But then the other financial benefits that has to be now restored, that has not come, my lord. And I had also indicated, my lord, in one of my affidavits, because there are so many affidavits, that how this pay has come out. The persons who are appointed without benefit of this particular order in the same rank, however, they are drawing 68,000 and these persons are drawing, who are senior and appointed in the 90s, they are drawing 62,000 because of this implementation.
That becomes too complicated then.
I'm not going to those facts, but then what was the purpose of the Fifth Pay Commission was to enhance your pay, was not to reduce your pay.
Well, civil contempt, I have never heard argument. Well, the criminal contempt, of course.
No, it's one thing to say that rightly or wrongly we have complied and therefore a fresh cause of action would arise. But then here, my lord, we have made out a case where there has been a subversion, my lord, where the facts that were argued earlier in the writ petition and also before the Supreme Court in the SLP has now subsequently during the implementation again has been nullified, bringing us back to where we stood. In fact, in a worse position than where we stood. One step below where then we used to stand, my lord.
Okay, we won't segregate them. Let you file a chart and we'll dispose it of next day.
My lord.
You know, what Mr. Patel is saying is true. That they don't want to go undertake the hassle of, they understand very well why they're seeking, to keep this fire burning.
And one person is trying to.
Once it's extinguished, they have to, again go back to, it's like snakes and ladders, you're getting swallowed right before 99.
99 and you come back to one.
Then you have to face the hazards again. Now you have to face the hazards again.
Precisely taking the same way, my lord. If in the cases where other persons had come, a few persons had come in a writ petition.
Well, the fact that this contempt
that will be again
is for 10 years, my lord.
That is going in appeal again.
Writ petition wouldn't have taken 10 years, my lord. Writ petition wouldn't take 10 years, my lord. Even appeal will not take 10 years.
Dismissal of the SLP balance, there will again be compliance, and compliance will again
you take this back. After hearing some time.
Even this file has become unmanageable now.
Yes, the order sheets are thicker than the file. Yes, after hearing at some time, after adhering some length, it appears that. No, after some length, item number 2, Mr. K. Paul and the senior counsel, please be allowed to file a short chart, CHRT, showing how the petitioner has been adversely affected on non-implementation of the orders of this court. Stop. How much? 1 week's time? 2 weeks? So you pay for.
But the file an affidavit, my lord. Chart will not chart will not help, my lord. Chart on affidavit with affidavit, my lord. At least I can take instruction then, my lord.
Yes, sir. This item number 1 is together also.
Item 20.
Sorry for them also. See, the thing is that what has been given, it's. But then even contempt also, to what extent can we raise hands? Apart from making good civil imprisonment for 1 day, that they won't get on the money also.
No, promotion they already got, my lord. Promotion they got, ACP they got ACP, MACP, everything, my lord.
Now the thing is that, fine, contempt one stage now, only a notice. So if we find there's some, then we'll have to issue notice again on contempt proceedings under the High Court rules. That will take again show cause.
I can assure the Honorable Court, if that happens, the compliance will happen within 24 hours.
Ministry will immediately intervene.
The same thing happened once notice of contempt was issued. Compliance came before 24 hours.
Yes.
20.
Yes, maybe we have to.
Well, can file an affidavit.
They'll file affidavit.
Affidavit.
Yes,
matter may be listed 1 week thereafter. We may file with it within 2 weeks, my lord, and 1 week thereafter, so that he can have instructions, my lord.
My lord.
Yes.
They have to reply, my lord. They have not filed any reply to the additional affidavit filed by the petitioner.
They have not filed?
No, my lord.
To what?
Who is competent authority to inflict the punishment, correct? Yes.
Well, just because of oversight, my lord. But can you give
oversight?
1 week's time, I'll file an affidavit.
Too busy now.
Overburdened, my lord.
They filed in November. Mr. Dr. Mosika, please was allowed how much time?
10 days, a week or 10 days.
To seek instructions on the additional affidavit filed by the writ petitioner just after 3 weeks. Yes.
22.
So show that letter again.
Yes, Your Lordship.
Now it's out of employment.
He's out of employment.
What's he doing?
He's doing nothing, Your Lordship, as of now. He's 47 years of age, Your Lordship.
How is supporting himself?
Nothing. His wife is working, daily laboring. He's just helping.
Just sleeping?
Helping.
Helping.
Anyway. So it has come to our knowledge also, Your Lordship, that the post he was initially appointed as officiating typist, Your Lordship, for 6 years without break, 2001 to 2007. Vacant, Your Lordship. Because the person who he has been officiating in that post, Your Lordship, he got promoted to LDA. Until now, it's vacant, Your Lordship.
But thereafter, Your Lordship, last appointment was by the project director.
Doesn't matter.
Doesn't matter.
What this code is saying, like, accommodations against some of the contractual vacancy.
So, Your Lordship, I have requested through my letter also communicating
Yes,
Your Lordship order, but
yes, pursuant to the order dated, what order dated? 28/3/25, passed by this court. MS Bharatsaji has produced a communication dated 25/04/2025 by the Director of Urban Affairs, indicating that presently there is no vacancy in the department, and that the case of the petitioner for engagement of temporary or engagement on temporary contractual basis will be considered if any vacancy arises in the future. So the communication is noted and taken on record. Well, be soon, however, for the writ petitioner submitted that it is to the knowledge of the petitioner that the post of typist against which the petitioner had initially officiated is presently vacant. And if MS Esbar Haji to take instructions as to whether this is the correct position.
yes, sir.
Yes, just after 2 weeks.
Your Lordship, this is a recent judgment also passed by the Honorable Supreme Court on 30th.
Yes,
If
but
I
that's
may-
again
But
that's
there is
different.
break in service also, Your Lordship.
No, we're not talking break in service or broken service. This is a question of mercy petition as he is
Mercy
submitted.
petition, yes, Your Lordship, I
We're
understand.
not talking technicalities. Even this court orders it won't
Yes,
be
Your
proceeded.
Lordship.
Yes.
I'll communicate Your Lordship.
24. I'll oblige.
Your Lordship, 2 weeks time may be granted for much obliged.
It will come up after 2 weeks. Mr. Chanda is not available today.
He's on legs.
No, Lordship, he's not available today.
What's the matter about?
This is regarding remonstration, Lordship. Even I'm supposed to file my rejoinder also, Lordship. I'm filing it.
Well, that's why you want adjournment.
Lordship, it's fixed for hearing also. After 2 weeks.
Just after 2 weeks on the prayer of souls.
Obliged.
27.
Lord, the matter pertains to the pay structure of the High Court officers and staff, Lord.
Who's appearing this
Lord,
matter?
Learned AG is.
Learned AG is here, my Lord. My Lord, we have a part heard before the division bench 1, my Lord. I don't know whether we'll be able to conclude this.
Issue, my Lord, is the identical issues.
Let me open, my Lord.
Yes, sir.
My Lord, I have.
You want adjournment?
No, my Lord. We can start, my Lord, and then continue tomorrow, my Lord, because of judgments which I have to point out. Because
put in a clear day. I'm not going to have.
I have very
okay, my Lord, then coming week, my Lord.
After 2
Any
weeks,
day
my Lord,
coming.
because the identical matter is pending before
my
the
Lord.
Honorable Supreme Court. That is my case. I will supply the writ petition and the order also, my Lord, so that my friend can go
The
through
issue
it.
here is, my Lord, recommendation has been given by the Honorable Chief Justice, my Lord, and the
Yeah,
government is
accepted
sleeping
by
over
the-
it.
Yes, Steve, I understand. Just after 2 weeks on the prayer of the constitutional parties. Yes.
28 is connected, my Lord.
20 is connected.
28 is also confirmed, my Lord.